In today's lecture, we're going to be looking at Chapter 5 of the text concerning the dynamics of courthouse justice, how the actors work together, basically how the courthouse operates. So the courthouse, try to think about what a courthouse looks like. Oftentimes, they're very imposing structures. They're built in older styles of architecture. Sometimes the large columns and things like that. More modern buildings have a more modern architectural feel, but they still have a lot of the sort of old world inspiration. They're not very. They are intricate, but intricate in their simplicity. There's not a lot of extra space, extra buildings. They're fairly utilitarian, um, and we'll look at some of the reasons why that is going forward. Um, they often have their own sort of little community around them. They'll have restaurants where individuals can get lunch. There's going to have a lot of lunch traffic there. Sometimes they're not open on the weekends. It really just depends on what the traffic is like in those areas. If you've ever been to downtown Atlanta around the courthouses there, at least the city courthouse, there's a few restaurants, but again, a lot of those are in uh, right around the courthouse, and again, they basically have the same hours as the courthouse there itself. The buildings are designed for people to come in and out of fairly orderly, regularly, but they also have entrances built in for the judges for the ability to move people in and out without a lot of attention. So it's sort of that dual purpose there. Inside the courtroom itself, the people that are there, you have the bailiff, who's basically the one keeping order. If you want to think of it like a bouncer at a nightclub, letting people in, potentially removing people that are problems, calling the court to order, making sure everything runs appropriately. You then have the court clerk, who is basically kind of like the manager almost, making sure the judge has the information that they have, making sure that the judge is informed about motions, things like that. An issue where someone doesn't show up, so the judge has information about that. Basically, doing all the little things that need to be done for the court to operate. And you also have the court reporter, who is there keeping record. Typically, that's verbatim, unless the judge requests something not be in the record, be stricken from the record. Once it's already been recorded, or potentially to not record certain aspects of the trial. That could be for privacy issues, could be for legal issues. But the court reporter is there to keep a record of everything the judge feels record needs to be kept for. You have the judge themselves, who is uh, we're going to talk more specifically about judges' roles later on, but basically in the courtroom, they're the boss. They're the ones making decisions about things. If a decision has to be made about the way the trial is going to operate, the way the courtroom is operating, the judge will be the one that makes that decision. They will have individuals working for them as well, judicial law clerks that are doing legal research for them, also a judicial secretary who is maintaining their schedule outside of the courtroom. So it takes a lot of people in large courtrooms that process a lot of cases for them to operate. Typically, also, there's a position, the clerk of the court, which could be in reference to the court itself, that sort of level of court and where they're at, sort of kind of like a manager of the managers. Again, these processes that we have in the criminal justice system are very bureaucratically based, so there's a lot of oversight for the various individuals that work throughout the system. So one of the things that we talked about before was sort of why courthouses are built the way that they are. The main reason is to control access into them and out of them. There has been fairly constant threats of violence against judges, against judicial systems, against courts, courtrooms, because a lot of times people have bad times in court. So they're reacting to something that the court has done, or they're potentially reacting to someone in the court proceedings, the defendant in a trial. There's oftentimes a lot of security that has to go into the protection of defendants in trials, and the courts are built to achieve that. So they have restricted access in and out. They have the ability to bring people in through other entrances if that needs to happen. Metal detectors, uh, closed circuit recordings of the proceedings. There's been a lot of target hardening of courts and judicial buildings as those technologies have developed. Also, you have things like emergency alarms, like you would see at a bank, where you can just sort of reach under the desk and push a button and call for help instead of having to phone someone or communicate with someone in another manner. Um, the reason that this happens is again sort of symbol of law. Um, the court proceedings are supposed to be fair and impartial. When you bring things in like threats of violence or actual acts of violence, it makes the process not be able to be fair. And it's a very difficult process. The people that engage in this do a tough job, and it's something that we have been very proactively protecting in this country. There was a sort of conflict of this in recent times over the last few months. There were threats to burn down a federal courthouse in Portland, and because of these threats, regardless of how serious they were, in this case they were probably pretty serious, probably potentially could have happened. Instead of letting that happen, the current president decided to send unidentified federal agents to try and prevent this acts of civil disobedience. And this was a case where the sort of stick-to-itiveness, the preemptive protection for the courthouses was improper. The negative attention that sending those federal troops to break up what in some cases were peaceful protests preemptively, with the thought that they might commit violence later, the negative effect that has had is not worth saving the building. And it's weird to think that, but in my opinion, and that's my personal opinion, it would have been better to let a mob burn down a federal courthouse than to infringe upon liberties as was done in Portland. So you have these issues where the legality and the morality are sometimes in conflict, and there's probably no more that doesn't happen in any other aspect of the criminal justice system more than in the court system, where you have legal requirements conflicting with what we call moral obligations. For police officers, it's not as rigid. We give them more discretion in their ability to make decisions about what should happen when people coming into the system. The courts don't always have that luxury. We also see some of the issues with courthouses is that a lot of people are coming in and out of there. It makes the protection that much more difficult. They've also been seen as a smuggling point for the correctional system. And really beyond the courthouse itself, those courthouse members, judges, clerks, and things like that, see a lot of threats. Between 2003, 2008, we saw over 5,700 threats against judges in courthouses. So again, we've been engaging in the target hardening. Also been it's been a policy to keep things like judges' information, their addresses, telephone registrations, things like that, off of public information. So you can't get information on a judge like you would be able to get even other government officials. Also, they're sort of told, and it's their best practice, to do things like not check into places on Facebook and tell their potential assassins where they might be. So judges are good about doing that themselves, and we also have taken formal steps, to reduce the access to their identities outside of the courtroom, and also where they live and things like that. So the sort of the workings of the system, while we strive for streamlined justice, fair justice, equal treatment among the law, these are still individual trials. So individual factors have to be considered in every case. There's also discretionary decisions that are made based on a wide variety of things. And it's important to note that judges and the people that make up these systems are people. So if they've had a bad day or they've had a bad month, or they're running for an election, those things shouldn't impact their decision from the perspective of the person receiving the justice, but they do. They do impact the way that the court operates. One thing that is very misconstrued in fictitious portrayals of courts is sort of the ease of operation. That's not the case. These are very long, drawn out processes. Oftentimes, you have to have multiple hearings before a trial can even start. Trials often start months, if not years, from when a crime was committed. So it's definitely not as cut and dry as you might see in film and television about the way courts operate. We do see a lot of assembly line justice. In some cases, that can be good. In some cases, that can be bad. For processing low-level offenders in a municipal court, that can be good. When you're looking at high-level drug felonies in federal court, it's not so great. So again, we see a lot of people sort of getting ground up by the system. They don't get that individualistic care, that sort of due process trip through the system. It's instead more dependent on how much evidence is stacked against them, how strong the prosecutor thinks their case is, and a lot of times those things are very weighed against the defendant. But like with anything in the CJ system, there are discretionary moments. What the prosecution is actually bringing. How does that impact what the judge can sentence a person to? Those things you have to look very specifically in individual cases to see what's actually going to happen in an individual situation. Because of that, because of the level of discretion, there are potentials for abuse, and judicial misconduct and abuse of judicial powers can be very, very problematic in the perception that people have of the justice system. For instance, there was a juvenile justice issue in Pennsylvania where a judge was sentencing basically everyone that came to his court to incarceration because he was getting paid from the company that ran the juvenile facilities. So there is a lot of opportunity when you have that discretion to have wrongdoing. But at the same time, that discretion can also be beneficial if it's used in a positive manner to have individualized, tailored justice for a particular person. So one of the things that is important in the operation of the courthouse, and it really addresses a lot of these issues that are listed here on the slide, is that whatever happens in the case that we're reviewing today, the prosecutors, the defense attorneys, and the judges have to work together tomorrow. So they have to respect what the other individual's role is in this process, and they have to understand, if a judge ruled one way on a case yesterday, they're probably going to rule the same way about that tomorrow. So it doesn't do any good for yourself, particularly as a defense attorney or your client, to try to argue the same point when you know that it's not going to be successful. You have to have the sort of professional courtesy and sort of society, the normal socialization that goes on within this work group. You have to know those social norms. You have to know what things judges are going to tolerate and what things they're not going to tolerate. Some judges might be particular about the way a motion is filed, or the way an attorney dresses, the way they address the court. You have to know those things and how to best handle the situations that might come up in a particular courtroom, because again, these systems are made up of people. So one of the issues that comes up a lot of times in a court proceedings is the speed at which justice is handed out. The court's very backed up. In Fulton County, a trial for a felony charge might be 18 months to 2 years after the crime actually took place. So depending on where you are, depending on how backed up the court is, that can affect uh, how long it's going to be before you're going to be able to have your day in court. You're going to see justice. Um, that can be, in some cases, individuals try to push that off as long as possible. If they know they're guilty, they know they're going to be convicted, you might want to delay the process as much as possible. On the other hand, someone that can't get bail and is sitting in the Fulton County Jail for 18 months because they can't get bail before their trial, they're probably going to want a quicker process. So it's really it's especially in state level courts. There's not a hard set requirement of how long a speedy trial is, but the whole system itself is very backlogged, and that's a condition brought on by the flood of cases coming into the system that are having to be processed, the failings of the mental health system, the failings of our veterans programs, the failings of our drug enforcement systems have put an undue burden on the court, and it makes it impossible for anyone to seek justice when the entirety of the system is so backlogged. As I said before, you also have the issue of ethical decisions that come up. Legal ethics are based on what the law says someone should do in a situation. And then you have moral ethics, which are basically based on people's internal compass, how they feel about a situation. And sometimes they can be in conflict. If, for instance, trying to think of sometimes attorneys will have to weigh issues of putting people on the stand that they may or may not know are going to tell a lie. Legally, you're not allowed to put people on the stand that you know are going to tell a lie. But if you don't know for a fact that they're going to tell a lie, that's the way a lot of attorneys can sort of wiggle their way into what kind of cases they present. But it's something the conflict between legal ethics and moral ethics are something that everyone has to sort of take under consideration for themselves when they get put in those situations. Everybody likes to think they would stand up in those situations and do what is morally right. Well, at least what they believe is morally right, but that's not always the case. So it's just something that is a ever-present part of the legal field. To that point, though, the defense's job is to provide the best ethical defense possible. So not putting people that are going to lie on the stand, not presenting false testimony or false evidence, and sometimes that can be a fine line. We do see different ethical issues come up for different individuals. So the prosecution has a different set of rules than the defense. The judge has a different set of rules than both of those individuals. So it's, again, really just based situation specific on what types of things come up, and then what type of decisions those individuals have to make. Which is why it's very important that they be very heavily and positively trained in whatever their role is going to be in the courtroom work group, because this process and the eventual outcomes are extremely important to the individuals being processed by the system. Okay, so be sure to watch the other videos this week about the individual actors in the courtroom proceedings. The next one will be on prosecutors.